We're ready, Judge.
Okay, I will go ahead and click on this, the YouTube click. All right, let's go ahead and start calling cases.
Okay.
Which one's the first one?
Bottom of page 9, Judge. Annex, may we have Eddie Morris?
Is there coming up? First, people? Yes. Sunshine.
In cause number 2018-0D01845, State of Texas versus Eddie Morris. Announcement of council, please.
Alyssa for the state. State is ready.
Alyssa on behalf of Mr. Morris, we're ready, Your Honor.
David Bruce, adult probation.
Okay, this case is set for a probation status hearing. So who wants to tell me what is the status of the probation for Mr. Morris?
Right now, Your Honor, he's in custody due to not reporting for a while. He had absconded. And at the last hearing, we were going over his mental health assessment at the jail. He was to be screened to see if he would qualify for Takumi, mental health caseload. Now, with that, the results were a little late, but they did say that Mr. Morris had declined services with them. So when they did the assessment on the 20th, he already declined services, but that's why they gave no mental health diagnosis, no medication. He didn't want any medication. So he is taking therapy. He was seeing a psychiatrist at the jail. So in lieu of medication, he was doing the therapy. If he were to be released and put back on probation, he could still continue to get services with EHM, which is the mental health services place. And he could get a caseworker and everything, but he would have to be assessed by the doctor again because in the jail, it is a controlled environment. So it was okay to not have the medication prescribed there. However, on the outside, there are multiple stressors and that may factor in. So the doctor has to have an assessment with him again, the doctor on the outside of the jail at least, to assess and see if he needs any medication. And based on what happens on that appointment, then he can continue with the services of the EHM.
Is that session with the doctor scheduled?
No, that would be scheduled once he is released. They can get that going and we'll go from there. But as far as probation, he already had completed the required courses as a part of the domestic violence caseload with me. He already completed the BIT program. He completed court costs. We were just going to send him to regular because he has pending community service hours. He has about 80 and he has probation fees pending.
Okay, well, I mean, what are we going to do for right now? We're going to keep him in or are we going to let him out? What is everybody's position on this?
Your Honor, this is our third hearing. We had one on March 30th where the judge wanted some type of assessment and exit plan. And then we had another hearing on the 25th. However, it took a little longer to get him assessed. And he's actually been in custody since February the 4th. I did speak with Mr. Morris, and according to him, he did already reach out to EHN, and he does have, he's going to schedule an appointment. He already spoke with them. He does have a stable residence. My understanding, Judge, is that the medication that doesn't give him as many side effects is not prescribed at the jail. I think it's Latuda, but once he's released, he can make arrangements to continue therapy and take that medication. So my understanding is he's not wanting to comply with taking meds. The problem is that the medication that doesn't give him as many side effects is not prescribed while he's being detained. So he'd like to go out and reach out to EHN, which he already did, and continue with speaking with a therapist and continuing on medications, just the medication that won't give him as many side effects, Judge.
What's the district attorney's position?
Judge, before I do that, I'd like some clarification because I looked at the probation report and an email stating that he has a pending assessment. The referral was submitted on 4/5/23. It's recommending that the court provide us with more time to get Mr. Morris seen by a psychiatrist in jail. So my question is for Mr. Bruce, is that not what is happening here? Because otherwise.
No, he was assessed at the jail. However, that's a different doctor from each doctor on the outside. They have two different doctors. He was assessed initially. I didn't have that answer ready for the hearing that we had on the 25th. It was because on the first response that I got back from on the assessment only said no mental health diagnosis, no medication. They didn't specify whether that was from the doctor or is that based on because he didn't want services. So I was able to follow up after the hearing and able to get that clarity saying that, yeah, he had declined services. However, he was seeing psychiatrist there for therapy. So he was getting that kind of service. It's just, I didn't have that the previous hearing. I have that now though.
So a psychiatrist has seen him in jail
Yes, he was being seen at the jail by a psychiatrist.
and they said no mental issues.
They gave me no mental diagnosis.
They did not give a diagnosis. The state's position is I would like to know if there's a mental diagnosis before he's just released. And we just hope that he does take the medication that he's okay with. And the reason why, Judge, is this is the state's third motion to revoke. He's got a prior pen trip. I'm not exactly sure that I'm on board with just continuing probation. And I need a little bit more than just saying, you know, please, let's just hope he gets on medication. That's what I would like to see. So, Ms. Solis, if you have anything that shows that, and he also stopped reporting. I mean, I have a lot of concerns, Your Honor, to be honest with you.
Your Honor, and I understand that. It's just at the last hearing, the judge did stress she wanted some type of plan. And as I mentioned, he has reached out to EHN, and his intentions are to go and start taking whatever medications they deem fit. I'd like to request if the court would allow him maybe some type of release and maybe a status hearing in 30 days, just to make sure he's compliant with the court's orders. Because he is set to term, but he has until 2028, Your Honor. He was given 10 years probation. But I'd like to see if the court would consider allowing him a chance to get all of that resolved and possibly leaving that open, but setting him for some type of status hearing, maybe like in 30 days to make sure that he's compliant.
Okay, he has been in jail for 91 days.
He's been in custody since the 4th of February, Your Honor, yes.
Okay, Mr. Bruce, tell me again, you said that he was seen by a psychiatrist, but the psychiatrist had no assessment?
During assessment, like I said, they put no mental health diagnosis. So that's what they placed on the assessment that they had done on him that were requested for him to be assessed for mental health. I'm not clear as to why if there was a mental health diagnosis, if they're just not telling us, but this just says no mental health diagnosis. That's all that they were disclosing to us when they contacted the jail.
And Your Honor, again, from my conversations with Mr. Morris, it's because the type of medicine that he was using that doesn't have the side effects, it is not an option in custody, Judge. That's why he's reaching out to EHN.
All right, well, the state has some concerns about letting him out. And you've got some concerns about how long he's been in and wanting to get him out. What treatment is there that he would get if he was on the outside that he cannot get in the jail?
Your Honor, my understanding is the medication, again, that he was taking, the Tudas would be through EHN, and that's why he reached out to them to try and schedule some appointments, but obviously he needs to not be detained. Judge, before I forget, there was another little issue which was brought to my attention this morning. Mr. Morris indicated that he did suffer some type of a health problem on Friday. I don't know exactly what it was, a mini stroke or something, but he did have an issue this past week. So I would like him to also seek medical attention for that as well, Judge.
Okay, Mr. Bruce, do you know anything about this recent medical situation?
No, Your Honor.
When's the last time you saw the defendant?
The last time I saw him was during a jail visit because I have to get him to sign the consent forms to have access to the mental health assessment that we conducted. Saw him on 4/19/23.
That's like 2 weeks ago. Maybe a little longer.
About that long.
Judge, if I may, I'd like to add something.
Go ahead.
I'm not seeing a real treatment plan really set up here. In addition to that, we have an aspect where he's not even reporting. My position or the state's position right now hasn't changed from revocation. And we're not set for a bond hearing today or any modification on bond. And we would not be waiving our 3 days on that. Should Ms. Solis wish to file another bond hearing and then consider that. But I'll let the court know that I don't see a real set treatment plan other than what Mr. Moore is okay with taking or not taking. I'm not, I know there's history here. I wrote a note that he had a prior pen trip. I don't see I have concerns about just releasing him to the community with no real treatment plan. And as to his medical conditions, what is it that the jail is not doing that can address that? Because I know we've had this in the past in a different case. So I guess that's the state's position right now. We would object to modification of Mr. Morris's bond at this point. I'm not waiving my 3 days to hear that.
And Your Honor, we've already had a bond hearing. My client's unable to make any type of bond at this time. So we did have a bond hearing back on the 21st of February, and the bond was set at 60,000 cash surety, 5,000 PR, but he has no way of making bond. He does have a stable residence, as I mentioned. I mean, my understanding is the court could impose any conditions that the court sees fit as far as giving him a certain type of time period in order to go to EHN and set up some type of counseling or get some more information that I can provide to the state judge. Again, I would ask if we could do something like that and possibly set him for some type of status hearing in 30 days or whatever the court deems fit.
Well, what I think I'm going to do is reset this for 1 week. And at that time, it can be a status conference, a bond hearing, a motion to revoke, whatever either side wants, but let's address everything that needs to be addressed and make a decision. I mean, it's easy for me to say because I won't be here next week. That'll be Judge Perez, but I think we need to act as quickly as we can to do what's right for the community and what's right for Mr. Morris. So let's, Ms. Solis, you okay hearing this thing a week from today?
Yes, Your Honor, that's fine.
All right, we will put it off for 1 week, and if anybody needs to file motions requesting any relief, get those filed as quickly as possible on either side.
Yes, Your Honor, I will do that.
Let's see if we can get this addressed with some level of finality next week.
And Mr. Bruce, if you could tell me if any of these assessments could be done in jail, that would be also very helpful.
Like I said, he did the EHN assessment there, but because it's like I said, when it's outside, it's a different service he's going to be getting. When he gets screened for Takumi on the outside, he gets assigned a caseworker who, based on the level of care that the assessment with doctor there, he can be seen weekly, he can be seen once a month. He does have appointments monthly with the doctor
So he
for
did not
medication.
in jail.
What we got so far, that's the assessment that they conduct.
Okay, thank you.
All right, well, this will be reset for next week. Everybody file any motions you want to have filed, and let's have a decision made hopefully next week.
Yes, Your Honor.
Thank you, Judge.
Okay.
Thank
Mr.
you.
Morris, good luck to you, sir. Okay, Mr. Marufo, do we have any others ready?
Yes, Judge.
Excuse your honor. Sorry.
Yes.
Thank you, Your Honor.
You're not here on any others, are you?
No, Your Honor. This
Okay,
is-
yes, you are excused.
Maybe excuse, Judge?
Yes.
Okay, thank you.
Thank you.
The next one is on page 10, Judge. Annex, may we have Junior Soto?
This is a plea hearing, right?
Yes, sir.
Yes, Your Honor.
Okay, let's go ahead and call this one. I see Mr. Darnell's picture on there.
Because number 2022-0D0-1143, State of Texas versus Junior Soto. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Chief Darnell for Junior Soto. Mr. Soto is there. He is present by way of video conference from the El Paso County Jail Annex. We're ready to proceed.
Okay, it is my understanding that this is scheduled for a plea. Is that correct?
Yes, Your Honor.
Your Honor, I do only see only one cause number was called, but I sent plea paperwork on 2 cause numbers.
And those were sent to the court on both as well.
Okay, the one that I've got, I don't know if I've got 2. I've got cause number 2022-0D0-1143.
You should have 2019-0D0-1839 as well, Your Honor.
Let me see if I do. I got a big stack. I do. I
Okay,
have it
perfect.
also. Okay. Mr. Soto, I am going to ask you some questions. Would you please raise your right hand, sir? Do you swear that the answers you're about to give to these questions will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Okay. Mr. Soto, you have signed a number of documents, but I'm going to go through them with you and just make sure that I am satisfied that you fully understand what you are doing and that you are doing everything freely and voluntarily. There is a waiver of rights, and I'm going to go through these one at a time. With regard to both cases, you have a right to plead not guilty, and by doing that, force the state to prove each and every element of the offense you're charged with beyond a reasonable doubt. You've got a right to trial by judge or jury to determine guilt or innocence, and if necessary, to address punishment. You've got a right to at least 10 days to prepare for trial. You have a right to compel the attendance of witnesses, which means if there is a witness that could give testimony helpful for you, you've got the right to have a subpoena be issued and served and have that person be forced to come in and testify. You have the right to confrontation and cross-examination. So if anyone was testifying against you, you would have the right to be present, see what they say, have your lawyer cross-examine them. And you have a right to remain silent. You would not have to testify in any trial, and that if you chose to remain silent and not testify, that could not be used against you. Do you understand all of those rights that you are waiving by entering a plea?
I do, sir. Yes.
Do you understand that you're giving up those rights by making a plea guilty?
Yes, sir, I do.
I'm going to ask you about your citizenship. Are you a citizen of the United States, sir?
Yes, sir, I am.
Okay, that is an important question because if you were not, there would be very serious immigration consequences that could flow from a plea.
I am American.
Okay. It looks like you are both cases the same. They're both second-degree felony, aggravated assault with a deadly weapon. Is that correct?
Yes, sir.
And he is pleading guilty to both. Is that correct?
Yes, Your Honor.
All right.
Actually, 2019-1839, Your Honor, I have as an assault with a previous conviction.
Which is an F3, but Judge,
Yeah.
when you're referring to one cause number, there are 2 counts of aggravated assault. And then there's a separate cause with only 1 count of an AFE, a 3rd-degree felony.
Right.
Okay.
So there's 3 charges in total.
And he's pleading to 2, not 3. Is that correct?
He's pleading to
2
3.
causes, 3 counts.
Oh, okay. And he's pleading to each count.
Yes, sir.
Okay. And that is your understanding, Mr. Soto?
Yes, sir, it is.
Okay. You understand that there are firearms and ammunition limitation? By pleading guilty, you are giving up your right to purchase or possess firearms or ammunition. Do you understand that, sir?
Yes, sir, I understand.
Okay. Okay, you have signed documents indicating you are waiving all of these rights and freely making your plea of guilt. You have signed a judicial confession. Mr. Darnell, I'm going to ask you, are you satisfied that your client is competent and is able to communicate with you?
Yes, Your Honor, I've spoken to Mr. Soto and met with Mr. Soto on many, many occasions, and it is my expert or my professional opinion that he is competent.
Whether that's expert or not, that is.
Yeah, at this point, it's iffy.
Okay. All right. It looks like the recommendation that I am seeing is 3 years confinement in the Texas Department of Criminal Justice. I assume it's through on each count and that it is concurrent. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
All right. Is that your understanding, Mr. Soto?
Yes, sir.
Okay, I will find that you are pleading guilty voluntarily. I will accept your plea. Does the state wish to summarize the evidence in these cases?
Yes, Your Honor.
You may go ahead and do that.
Thank you. As to cause number ending in 1143, had this case proceeded to trial, the state would have been able to prove that on or about the 30th day of March 2022, and interior to the presentment of this indictment in the county of El Paso and state of Texas, Junior Soto, hereinafter referred to as a defendant, did then and there intentionally or knowingly threaten Claudia Flores with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a knife, that in the manner of its use and intended use was capable of causing death and serious bodily injury. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a knife, during the commission of an immediate flight from said offense. There's an enhancement paragraph. We are abandoning that enhancement paragraph, Your Honor, and moving to count 2.
Okay, you may continue with regard to count 2.
On or about the 30th day of March 2022, and interior to the presentment of this indictment in the county of El Paso and state of Texas, Junior Soto, hereinafter referred to as defendant, did then and there intentionally or knowingly threaten Claudia Flores with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a rifle, that in a manner of its use and intended use was capable of causing death and serious bodily injury. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a rifle, during the commission of an immediate flight from said offense. Enhancement paragraph abandoned, Your Honor. And I move now to cause ending in 1839.
You may proceed.
Had this case proceeded to trial, the state would have been able to prove that on or about the 30th day of November 2018, and interior to the presentment of this indictment in the county of El Paso and state of Texas, Junior Soto, hereinafter referred to as a defendant, paragraph A, did then and there intentionally, knowingly, or recklessly cause bodily injury to Becky Reyes, a member of the defendant's family or member of the defendant's household, or person with whom the defendant has or has had a dating relationship as described by section 71.003 or 71.005 or 71.0021B Family Code by dragging Becky Reyes about the body with the hand of the defendant. Paragraph B, did then and there intentionally, knowingly, or recklessly cause bodily injury to Becky Reyes, a member of the defendant's family or member of the defendant's household, or person with whom the defendant has or has had a dating relationship, as described by section 71.003 or 71.005 or 71.0021B Family Code by slamming Becky Reyes' body to the ground with the hand of the defendant. And before the commission of this offense, the defendant had previously been convicted of an offense under Chapter 22 Penal Code against a member of the defendant's family or member of the defendant's household or person with whom the defendant has or has had a dating relationship, as described by section 71.003 or 71.005 or 71.0021B Family Code, to wit, on the 20th day of August, 2015, in the 171st District Court of El Paso County, Texas, in cause number 2014-0D00877. And before the commission of the offense, the defendant had previously been convicted of an offense under Chapter 22 Penal Code against a member of the defendant's family or member of the defendant's household or person with whom the defendant has or has had a dating relationship, as described by section 71.003 or 71.005 or 71.0021B Family Code, to wit, on the 20th day of August, 2015, in the 171st District Court of El Paso County, Texas, in cause number 2015-0D03258. Your Honor, as to each cause number, the state has submitted State's Exhibit 1 plea papers and State's Exhibit 2 the disclosure forms. We ask that they be admitted into the record now.
Mr. Darnell, any objection to the admission of those exhibits?
No, Your Honor.
They are admitted. Any objection to the summary of the evidence?
No objection.
Okay, there is a question of his right to appeal. It is my understanding in this type of a plea bargain case, there is no right to appeal. Is that correct?
That is correct, Your Honor.
Okay,
Just briefly, Your Honor, I submitted 2 dismissal forms to the court earlier on cause number 2022-0D02139 and 2023-0D008.
okay, I've got a big,
Sorry, would you please repeat the last 4 of the second dismissed?
Yes, 0228.
okay, I've got a big pile of what was submitted to me, and if it is not in this pile, make sure I do get it and I'll sign it.
Just to confirm, Mr. Marupo, did Mr. Vandenberg submit those dismissals today?
Yes, Ms. Welch has them.
Okay,
Okay. Okay, there is then a consent to virtual pleas that has been signed by both lawyers and Mr. Soto. Mr. Soto, you are agreeing or consenting to have this plea by Zoom. Is that correct, sir?
Yes, sir.
I will go ahead and sign that. Consent. Okay, there are also disclosure forms which are lengthy. I'm going to ask the prosecution first. Have you made all of the disclosures that you're obligated to make in this case?
yes, Your Honor, and those were Exhibit 2 in each cause, and they were previously admitted into the record with no objection from opposing counsel.
And I think they were admitted, today. Mr. Darnell, are you satisfied the state's made the disclosures they're supposed to make so that you can intelligently consult with your client with regard to this plea?
They have, Your Honor.
Okay. Okay, I am going to find that you have made these pleas voluntarily. I am accepting these pleas. I will follow the state's recommendation. And you are sentenced to 3 years. It will be concurrent on each charge. I'm not sure the judgments are in the stack that I've got.
Your Honor,
Yes,
hi. So I have not created the judgments yet, but after docket is over, I will head over so you can sign some documents that need to be signed. And if it's okay with you, can I give you the judgments tomorrow?
yes. That
Okay.
will be okay. So I will sign everything I have to sign and double check on that. Is there anything further to address or discuss at this time?
No, Your Honor, not from the state.
Mr.
Your
Zarate?
Honor, yes, I would just ask that Mr. Soto be given credit, as I show it, from April 20th to April 7th of 2020. From July 18th of 2020 to August 1st of 2020, as he was incarcerated here in El Paso at that time, and then the case that he was incarcerated on was later dismissed, but I believe he should get credit for that time. And then from March 31st of 2022 to today.
State of any objection to giving him credit for that time served?
No, Your Honor.
Okay. He will get credit for time served on those, for those dates.
Thank you, Your Honor.
Okay, anything further from either side?
No, Your Honor.
Your Honor.
I think there is one other thing. I think on all of these judgments, they're supposed to have fingerprints or thumbprints, and I think what we did is we attach arrest records to get the fingerprints. Is that the way that,
That's my understanding, Your Honor.
do I need to make some sort of ruling for that to happen, or is that like,
I think it's pro
Automatic.
forma. I don't think there's anything the court needs to take
Okay.
up.
all right? Mr. Soto, good luck to you, sir.
Thank you, sir.
May I be excused, Your Honor?
Yes,
Good to see you, Judge.
good to see you. Tell your father hello. I heard he's had some health issues, so I hope he's okay.
We're getting there. We're getting there. It's been a rocky year, but he's getting better. Thank you, Judge.
You bet. All right, what's the next one, Mr. Marufa?
Top of page 9, Judge. Annex, may we have Mills, Philip Mills?
Oh, yeah. Bill Mills,
Don't put the show type.
okay, this is a status conference on Mr. Mills. Let's go ahead and call this case.
In cause number 2021-0D02641, State of Texas versus Philip Daniel Mills. Announcement of council, please.
Roa King for the state of Texas. Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Marcelo Rivera with the Public Defender's Office on behalf of Mr. Mills.
Good afternoon. It looks like this is set for a status conference. So why don't you all tell me what the status of this case is?
Your Honor, from what I remember, I'm sure that we were not supposed to have this status, but it just stayed on the docket. And we have a motion to suppress the statement already set on the court's docket. So that's all I have, unless Mr. Marcelo has something.
Yeah, I was under the impression this was canceled as well. I think we were talking about setting a follow-up status maybe a couple of weeks before the hearing on the motion to suppress.
So do you want to just have this be reset for a couple weeks down the road?
That works, Your Honor. I believe the hearing on the motion to suppress is I can tell us right now. Hold on. Okay, the hearing on the motion to suppress is June 26th. So maybe if we can have the hearing sometime mid-June, the follow-up, does that work?
That's good with the state.
Yes, Your Honor. I believe we have a jury trial set for June 8th and 9th in this court. Um,
I think
So-
we need to move quickly on the motion to suppress and the status. Let's see if we can move that up and do it. Can you hear the motion to suppress next week?
no, Your Honor, I believe, my understanding is we're keeping the motion to suppress hearing that's already set, but there was just a simple, quick status before the motion to suppress.
Okay, so this will precede the motion.
Correct.
Status.
Yes.
Okay, well, let's get it set. What date would the state like? And let's see if it's a workable date.
Your Honor, I believe June 1st would work, which is the Thursday.
Would that work for the defense?
Yes, of course.
All right, let's reset it for June 1st.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Excuse Your Honor.
Yes.
Thank you.
Ms. King,
Yes,
do we need that in person?
Mr. Marcelo just logged off. Let's go ahead and do it in person.
Okay, I'll send you the notice.
Thank you. Judge, may I be excused?
Yes, ma'am. You are
Thank
excused. Okay, what else we have coming up?
Second on page eight, Judge. Annex, may we have Miguel Ángel Garcia.
Garcia Miguel.
Okay, this is also a plea, correct?
Yes, sir.
Yes, sure. Well, that 1 year ago. 1 year.
Okay, let's go ahead and call this one.
Because number 2022-0D04459, State of Texas versus Miguel Ángel Garcia. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Garcia, we are ready.
Okay, it is my understanding we are here today on a plea, is that correct?
Yes, Your Honor.
Mr. Garcia, I'm going to ask you a couple of questions. You've signed a number of documents, but I'm going to go over them with you. You should be placed under oath for this, so would you raise your right hand, please, sir? Do you swear that the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you have signed a waiver of rights, but I'm going to go through those briefly with you. You've got a right to plead not guilty. And if you did that, you would force the state to have to prove each and every element of the offense beyond a reasonable doubt in order to obtain a conviction. You've got a right to a trial by judge or jury to determine your guilt and to have a jury determine your punishment. You've got a right to at least 10 days to prepare for trial. You have the right to compel the attendance of witnesses. So if there is a witness out there that could give favorable testimony to you, you would have the right to have a subpoena be issued and have that person be served and have him or her be forced to come in and testify. You have a right to the appearance and confrontation and cross-examination of witnesses. So if people were to be testifying against you, you would have the right to be there and see them and have your lawyer have the opportunity to cross-examine them. And you've got a right to remain silent. And if you exercise that right, it could not be used against you. You understand all those rights that you're waiving?
Yes, Your Honor.
Are you a citizen of the United States, sir?
Yes, Your Honor.
Okay. That's a very important question, because if you were not, there could be very serious immigration consequences. It looks like this is going to be a plea to a third-degree felony of invading arrest or detention with a vehicle. Is that your understanding, Mr. Huffman and Mr. Garcia?
Yes, it is, Your Honor.
Okay. Okay. Okay, you have signed a waiver of your rights, a plea, an acknowledgement, and a judicial confession of guilt. You signed all of those things voluntarily, is that correct, Mr. Garcia?
Yes, sir.
Okay, there is also an acknowledgement from your counsel, Mr. Huffman. Are you satisfied that your client is competent, he understands what he is doing, and he is freely and voluntarily engaging in this conduct today?
Yes, I do, Your Honor.
Okay. It looks like there is a plea agreement for 2 years confinement in the Department of Criminal Justice. Mr. Garcia, is that your understanding, sir?
Yes, Your Honor.
Okay, I will follow that recommendation. I will find, well, before I make that finding, does the state wish to summarize the evidence?
Yes, Your Honor.
You may do so.
Had the case proceeded to trial, the state would have been able to prove that on or about the 11th day of October 2022, and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Miguel Angel Garcia, hereinafter referred to as defendant, did then and there, while using a vehicle, intentionally flee from Adam Sanchez, a person the defendant knew was a peace officer who was attempting lawfully to arrest or detain the defendant. Your Honor, there are 2 enhancement paragraphs. The state is abandoning those, and we are asking that the court admit into the record State's Exhibit 1, the plea papers, and State's Exhibit 2, the disclosure forms.
Any objection to the exhibits, Mr. Huffman?
No, Your Honor.
Any objection to the summary of the evidence?
No, Your Honor.
Okay, I will find that the evidence does support a finding of guilt. I will find the defendant has waived the reading of the indictment. He has admitted the allegations. He has entered a plea of guilty. He is doing that freely and voluntarily. He understands the consequences of waiving all of his rights. He has waived the right for this to be done in person, and we're doing this by Zoom. It looks like this has, Judge Perez has already signed these documents, but I'm going to sign them also. Yeah, there is a disclosure form here. It is admitted as an exhibit. Has the state made all of the disclosures that it's obligated to make in this case?
It is my belief.
And Mr. Huffman, are you satisfied that the state has made the disclosures that it's supposed to make?
Yes, Your Honor.
Okay. Okay, this is a plea bargain case. So in terms of right of appeal, it is my understanding that there is no right of appeal. Is that correct?
Correct, Your Honor.
Yes, Your Honor.
Okay, I will sign that document. There is also a consent to a virtual plea. Mr. Garcia, what this means is you are consenting to the fact that we are doing this by Zoom, and rather than doing this in person. And you have consented to this process. Is that correct, sir?
Yes, Your Honor.
Okay, I'll sign that also. Okay, I will find that you have done everything voluntarily. I'll accept the plea. I will find you are guilty. I will sentence you in accordance with the recommendation. And it's my understanding that the judgments will actually be delivered to me and will be signed tomorrow. But with that understanding, is there anything further from either side at this time?
Not from the state, Your Honor.
Judge, I might have an issue. I'm looking through the court file and I'm not showing a waiver of arraignment. I don't know why there isn't one. There might be one in there, but maybe I'm just not seeing it. There was an issue with a case like this without a waiver. I was wondering if there's not a waiver of arraignment, if we could we've gone through the indictment multiple times, Judge. And he's got full knowledge of the charges. And I was wondering if we could waive arraignment on the record.
It's fine with me. Does the state have any first of all, does the state have a written waiver of arraignment?
Judge, may I?
Yes.
There is a waiver of arraignment signed.
Thank you. Scared me.
All right, that takes care of that. We were going to do it again if we needed to. Okay, so with that waiver of arraignment and with the understanding that the judgments will be presented to me and will be signed tomorrow. Anything further from either side at this time?
No, Your Honor.
Just so we just respectfully request that Mr. Garcia be granted credit for all the time that he served under this cause.
I will grant him credit for time served.
Thank you, Your Honor. That's all. That's all for the defense.
Mr. Garcia, good luck to you, sir.
Thank you, Your Honor.
Thank you.
Appreciate your help.
Takes care of that one. Do we have some more coming up?
Staying on page 8, top of page 8, Judge. Annex, may we have Manuel Castro.
Mira.
Good afternoon, sir. You are Mr. Manuel Castro.
Yes, Your Honor.
Okay, let's go ahead and call this case, Mr. Marufo.
In cause number 2022-0D03647, State of Texas versus Manuel Castro. Announcement of council, please.
Again, Alyssa for the state. State is ready.
Alex Shawala for Mr. Castro. We're ready.
Okay, Mr. Castro, good afternoon. This case has been set for a probation status hearing. So who wants to tell me what the status of his probation is?
Well, Judge, I've not had an opportunity to discuss this case with Ms. Elizalde. I don't know if where you're at, if you're, kind of hard for adjudication, or if we can kind of see his time that he's had in as a sufficient attention getter to get him on track and doing what he needs to do.
Is there a motion to revoke his probation?
Yes, there is.
Okay.
And Mr. Shaw, I feel really bad that I have to say this to you, but it looks to me like he might have picked up a sexual assault.
Okay, well, then that changes the game a little bit. I'm not appointed on that. I don't see it. Maybe it's still in the investigative stage.
From what I can see, it has been presented to our office. I didn't see it on the probation summary, Carla. So I'm a little hesitant, but I don't have an update on that as of now, other than it is in our office and it should be considered within the next weeks.
Okay, my docket indicates Mr. Castro has been in jail for 13 days since the motion to revoke has been filed. I think we ought to move very quickly. If there's going to be a hearing on the motion to revoke, let's try and get it done. Can we have a hearing next week?
Judge, I don't think I'm going to have any update on the sexual assault within such a short time period. I can tell you, Mr. Schwal, the offense date is 12/3/2022. So I have filed a motion to revoke, but
Well,
Okay, I can't hear you and you both talk at the same time. So,
Go ahead, Mr. Shawala.
I was saying, can I get the defense date? You said 12/3/22, is that correct?
Yes, that's the date of the incident.
Okay. Judge, would it, if, if the court's okay with it, maybe it'd be appropriate to give this a couple weeks. I'll go visit with Mr. Castro about this allegation, and that'll give Ms. Elizalde some time to
that's good.
move forward with that allegation. Because obviously this new charge is, more serious than what we're looking at here.
Okay, let's do this. Let's reset it for 2 weeks. And if either side thinks they need a little bit more time, they can ask for an extension from that. But let's at least for now, keep it on a pretty fast track so that we can try and address what we need to address as quickly as we can.
Thank you. There's Mr. Castro, I will come visit you this weekend, probably on Saturday, and we can talk about these new allegations.
And Judge, before we go, I did get notice that he was put on probation after the date of the incident. But for all intents and purposes, coming back in 2 weeks, we'll know more about that. I'm not sure if he's being held in jail for that offense as well. I don't know if someone can tell me.
I don't know either, but
We'll figure it out, Judge.
let's try and get that all figured out, and let's figure out what, so you can do everything you need to do in 2 weeks.
Okay. Thank you, Judge.
Okay.
Your Honor, if I may, just so that Mr. Shawala is aware, like Ms. Elizalde just mentioned, Mr. Castro was just placed on probation January of this year. But just to let the court know, he never reported to probation. He's never reported, and then he picked up a new offense, which was a possession of paraphernalia. Seems that it had meth on it, something like that. And this was back on April 23rd, and I believe that's since he's been booked in jail since then.
So I'm eyeing revocation at this point, Mr. Shawala.
Okay, well, I mean, I'm not ruling on the revocation today. He will stay in, and in 2 weeks, hopefully everything can be addressed at that time if both sides can get ready.
Okay.
Yes, sir.
And I urge you all to do that so that he can, we can deal with this as quickly as we can.
All right. Thank you, Judge. May I be excused?
Yes, you are excused. Do we have any others, or is that all of them?
Yes, Your Honor, Gonzalez, Danny, the last one.
Yes, sir.
Which one?
It's staying on page 8, Judge, bottom of page 8. It's
Bottom of
Gonzalez.
page 8.
Danny.
Danny Gonzalez.
Yes, sir.
Okay, this is a pre-revo hearing.
No, Your Honor.
Let's go ahead and call that case.
Because number 2020-0D01521, State of Texas versus Danny Gonzalez. Announcement of council, please.
Any other for the state? State is ready.
Rick Huffman on behalf of Mr. Gonzalez, we are ready.
Okay, Mr. Gonzalez, this is a charge of assault against a family or household member with a previous conviction. According to my docket sheet, today is set for a pre-revo hearing. So tell me what's going on and why we're having a pre-revo hearing. I'll hear from the state first.
Oh, okay, Judge, we did file a motion to revoke. And I did get an email from opposing counsel earlier this week asking me what I had planned to do. I know we discussed some possibly mental health issues, and I'm gonna ask for a little bit of help from Carla because I don't remember what the judge was thinking, and I think she did express this at the last hearing. Do you recall if she was thinking ACOP or Revo?
What I recall, and only because it was mentioned, or I brought it up, there was an email that was sent to Judge Perez back on November 10th, 2022. And this was regarding, unfortunately, Mr. Gonzalez is already under the special programs MHI caseload, mental health. And he was to participate. He was already been assessed, modified. He was referred, he had EHN appointments with doctor. He wouldn't report to provide drug testing. Fast forward to October 2022, that's when he started testing positive for meth. He was referred again for assessments through TAP. He was referred to EHN. There were appointments. He was just failing to show up to those appointments, although he was given those appointments. Judge ordered the bench warrant. And last hearing, we were at we were going to discuss something else because Mr. Gonzalez already had the opportunity to participate in all these appointments.
All right, well, I mean, it looks to, according to what I've got here, Mr. Gonzalez has been in jail for 64 days. So I think we need to move quickly and not just keep him in that status. Can we set this for a revo hearing?
I'm okay with that, Your Honor. Judge, can I just ask Ms. Pineda, I thought the recommendation for probation was an admonishment.
That is, as far as the probation officer's report is to have Mr. Gonzalez be admonished. Further states that he not be released from jail until he has been taken at least 30 days of medication. For Mr. Gonzalez to be re-referred to EHN Tacoma program for mental health services and to be referred to substance abuse treatment.
I think, Mr. Huffman, and this is what I was trying to remember, but I don't think it's in the probation summary. I know the judge had mentioned something either for ACOP or okay with revocation. And I think we need to hear from Judge Perez to see what she's inclined to do, because even if I agree to just some modification, she might not be willing to. Judge Speasney, I know you're kind of just hearing this from me, but I really would like to get clarification from Judge Perez before, because I know she had some thoughts on this case.
I think she should be the one to make the call.
Okay.
I mean, I'm just substituting for 2 days here.
Your Honor, and if I may, last hearing, this is the same kind of situation we were all in, because it was brought up that Mr. Gonzalez needed treatment and for him to seek further assessment, but he was already participating in all that, but he failed to do so, and he was continuing to use. So I kind of agree with Ms. Elizalde right now, just to kind of see where Judge Perez wants to go as far as further assessments, or I don't know.
Well, let's set this for next week. And it could be an admonishment or pre-revo hearing based on what the judge wants to do.
Judge, if I may,
You may.
Judge, I'll have to reset it for 2 weeks. The
Okay.
next jail docket is completely full.
Okay.
Thank
Well,
you.
we'll make it.
Sorry, Judge.
I think she said 2 weeks.
I was thinking, yeah, 2 weeks, and then maybe we can get a contested revo set like the week after. If that's okay, that way he's been sitting in jail for quite some time, and you know,
Can I speak? Can I speak?
no, not right now, there's no point.
It wasn't.
Not right now, man. I was just wondering is it Miss Guerra who's the probation officer? I'm still kind of unsure who his
Yes, it
people is.
Yes, it is.
It's still okay.
Okay.
I'll
Well,
give her a call, because I think some of that information is inaccurate, but I'll double check with Ms. Guerra.
okay, so this hearing will be reset for 2 weeks, and there will then be a contested revo hearing the week after that, if necessary.
I appreciate that, Your Honor.
What does that mean? Somebody explain to me.
Coming back in 2 weeks.
Coming back in 2 weeks, and what's that? Pre-revo.
Revo.
Huh?
In front of Judge, yeah, in front of
Either this time? This is the third time I come, and it's the first time they bring me to call.
We'll see, Mr. We'll see.
Okay. Anything further from either side at this time on this case?
No, Your Honor.
No, Your Honor.
Okay. Mr. Gonzalez, good luck to you, sir.
Thank you.
Thank you.